Things to consider when drafting your financial power of attorney. So, your financial power of attorney, also known as a durable power of attorney, is a document that authorizes someone else to act on your behalf with respect to financial decision making. So, for example, paying your bills for you, filing your tax returns, or even accessing bank or retirement accounts on your behalf. For married couples, they typically name their spouse as their agent, and if they have adult children, they'll name those people as their backup agents. But if you are not married or if you don't have adult children, then you may name a parent, a sibling, or perhaps an adult niece or a nephew or other close family member. Keep in mind that when you're drafting the financial power of attorney, you can make it effective immediately or a springing power of attorney. So, what that means is if it's effective immediately, as soon as you sign that document, if the person named has access to it, they can do all the powers you specify in the document. However, if it's a springing power of attorney, then that means it's only activated in the event you are deemed incapacitated. Usually a doctor would certify your incapacity. And until that point in time, that agent could not act on your behalf. Now, in practice, most powers of attorney are effective immediately for financial powers. However, if you are naming someone who is not a spouse or an adult child, you may want to make it springing power, meaning only effective if a doctor certifies your incapacity. And that's just a simple safeguard so other people can't access your financial accounts and that type of thing. Another thing to keep in mind, if you name more than one person to serve simultaneously as your financial power of attorney, we call that co-agents, then you should specify whether they have to act jointly or whether they can act independently. That's very important for when they're dealing with banks or other third parties, because if you don't specify it, then they'll probably make it a hassle for them to act on your behalf, which defeats the purpose of the document, which is to allow someone to immediately act for you if you become incapacitated.